discussion is fundamental right. This is a very important topic of Indian polity, important from APSC point of view and UPSC point of view. So I welcome you to the Prepare channel. Let's begin the lecture. Then fundamental right. These fundamental rights are enshrined in Part 3 of Indian constitutions, and they are the basic human rights guaranteed by the Constitution of India. So, Indian Constitution or our সংবিধানৰ Part 3 কি আছে fundamental rights খিনি আছে আৰু এইখিনি আমাৰ basic human rights যিখিনিক আমাৰ Constitution of India support কৰে guarantee দিয়ে, right? And the Article 12 to 35. Remember, Article 12 to 35 of Indian Constitution deals with these fundamental rights. Now, এইবিলাকক আমি fundamental rights বুলি কিয় কওঁ? Why they are called as fundamental rights? These rights are called fundamental rights because of two reasons. First, they are enshrined in the Constitution, which guarantees them. Second, they are justiciable, that is enforceable by courts. In case of a violation, a person can approach a court of law. So, দুটা কাৰণত আমি এই ৰাইটছ খিনিক ফাণ্ডামেণ্টেল ৰাইটছ বুলি কওঁ। প্ৰথমটো হৈছে যে এইখিনি ৰাইটছৰ বিষয়ে সংবিধানত উল্লেখ আছে, মানে সংবিধানে নিজেই এই ৰাইটছ খিনি গ্যাৰান্টি দিয়ে। সেকেন্ড, দে আৰ জাষ্টিচেবল, মিনছ যদি কোনোবাই এই ৰাইটছ খিনি পোৱা নাই বা এই ৰাইটছ খিনি ভায়োলেশ্যন হৈছে, ৰাইট, উলংঘন হৈছে, তেন্তে সেই পাৰ্চনজন যাৰ এই ফাণ্ডামেণ্টেল ৰাইটছ উলংঘন হৈছে, যোনে এই উলংঘন কৰিছে, তেওঁৰ এগেইনষ্টত সেই পাৰ্চনজন কোৰ্ট অফ লৰ এপ্ৰ'চ কৰিব পাৰে, ৰাইট, কোৰ্টলৈ যাব পাৰে আৰু তেওঁ ক'ব পাৰে যে তেওঁৰ ফাণ্ডামেণ্টেল ৰাইটছখিনি ভায়োলেশ্যন কৰিছে। So, এই দুটা কাৰণত ফাণ্ডামেণ্টেল ৰাইটছ বুলি কোৱা হয়। ফাণ্ডামেণ্টেল মিনছ বেচিক হিউমেন ৰাইটছ, okay? Then we have 6 fundamental rights. There are 6 fundamental rights. Basic important thing is that we need to remember the article number. So, right to equality, Article 14 to 18, right to freedom, Article 19 to 22, right against exploitation, Article 23 and 24, right to freedom of religion, 25 to 28, cultural and educational rights, Article 29 and 30, right to constitutional remedies, Article 32. আকৌ এবাৰ কৈছো, right to equality আহে Article 14 পৰা 18 লৈকে, 14 to 18, right to freedom Article 19 পৰা 22, right against exploitation of 23 and 24 article, এই দুটা article আহে, right to freedom of religion 25 পৰা 28 লৈকে, 25 পৰা 28 article লৈকে right to freedom of religion আহে, cultural and educational rights Article 29 আৰু 30 আহে, আৰু right to constitutional remedies Article 32. We have to remember the articles. Now come to one important means right that is frequently being asked in the exam, that is right to property. Right to property is now a legal right and not a fundamental right. So right to property to etia legal right he hoy kintu fundamental right noy, jodiu right agote ki asil etu fundamental right she asil. Originally right to property that was in Article 31 monot rakhiba, Article 32 right to constitutional remedies, tar agot Article 31 হেতু কাৰণে তো আমি পালো চাব পাৰা কালচাৰাল এণ্ড এডুকেশ্যনেল ৰাইটছত কোনটো আছে আৰু আৰ্টিকল 29 এণ্ড 30 মাজত এটা আৰ্টিকল নাই, মনত ৰাখিবা, হেতু হৈছে আৰ্টিকল 31। হেতুৱে আছিল আৰ্টিকল 31 that is right to property, যিটো নেকি বৰ্তমান ফাণ্ডামেণ্টেল ৰাইটৰ পৰা অতৰাই পেলাই লিগেল ৰাইট বনোৱা হয়। Okay, so this was done in 44th Constitutional Amendment Act 1978. So by 44th Constitutional Amendment Act 1978, 44 নং কনষ্টিটিউচনেল সংবিধান সংশোধন যেতিয়া হৈছিল 1978 চনত, তেতিয়াই this right to property was deleted from the list of fundamental rights and made a legal right under Article 300A in part, how many, what is the number? X 211, that is 12 of the constitution. Mono rakhiba article 2. Etia jitu amar article 31 asil right to property, now is in article 300A. Okay, and the question may be coming that by which amendment this was transferred to legal right and deleted from fundamental right? That is 44th Constitutional Amendment Act 1978. Now let's discuss the articles in brief. Means jikhini important points ase hekhini ami monot rakhim from the films perspective, and from the in the main also you can write like this table wise. So right to equality jitu 14 or 18 leke ase, right? So article 14 means equality before law. Article 15 means prohibition of discrimination. Article 16 means equality of opportunity in public employment. Article 17 means abolition of untouchability, and Article 18 means abolition of titles. 14 আৰু 15 বহুত ইম্পৰ্টেণ্ট. 14 এইটো কৈছে যে সকলো ইকুৱেল বিফৰ লৰ সন্মুখত সকলো ইকুৱেল, এণ্ড 15ত ৰেট আমাৰ যিখিনি আমাৰ ৰেচ সেক্স কাষ্ট, অকে, এণ্ড দেন সেক্স, এইবিলাকৰ ভিত্তিত কাকো ডিসক্ৰিমিনেশ্যন আমি নকৰিম, right? Otherwise that will be a violation of right to equality under the article 15. Okay, then article 16 মানে আমি equal opportunity পাম public employment ক্ষেত্ৰত, right? যিকোনো ষ্টেটতে যতে হওক public employment ক্ষেত্ৰত equality of opportunity থাকিব, and article 17 মানে যিটো মানে আপোনাৰ সুৱাসুত বা যিখিনি আমাৰ untouchability আছিলে হেতুক অতৰা হৈছে, abolition of untouchability, অস্পৃশ্যতা. So article 18 মানে হৈছে titles খিনি, other than educational titles, এইবিলাক titles like Maharaja, এইবিলাক অতৰাই দিবলৈ কোৱা হ'ল article 18 or under whole. Right to equality from article 13 to 18. Now next, right to freedom, that is coming under article 19, and it provides protection of 6 rights: right to freedom of speech and expression, right to assemble peaceably and without arms, right to form association of or unions or cooperative societies, right to move freely throughout the territory of India, right to reside and settle in any part of the territory of India, right to practice any profession or carry on any occupation or trade or business. Ekhini law protection, ekhini rights mane sota rights protection korise article 19 e. Then article 20 means protection in respect of conviction of for offenses. Then article 21 to बहुत important, protection of life and personal liberty. You will see that in some states even there are different amendments going on, or there are different inclusions are going on under article 21. Jeneke right to have net connection or right to internet is a fundamental right now. Can you tell me in which article that is in there included? Kuntu article under right to internet to include kora hoise as a fundamental right? Tumaloke comment kori janabo para muk. Then right against exploitation, that is article 23 and 24. Now article 23 is prohibition of human trafficking and forced labor. Then 24 means prohibition of child labor. Very, very important. Right against exploitation, article 23 and 24. Then right to freedom of religion. 25 says freedom of conscience, profession, practice, and propagation. 26 says freedom to manage religious affair. 27 means freedom from taxation for promotion of a religion. Then 28 means freedom of attending religious instruction. So you just need to remember that article 25 to 28 coming under right to freedom of religion. Yat etu khudhe je kuntu under je amar jikunu eta religion as মানে তোমাৰ কিছুমান ৰিচুৱেল কৰিবলৈ টেক্সৰ লগত যিখিনি জড়িত আছে সেই আৰ্টিকলটো কোনটো? that is article 27. Then educational and cultural rights come under 29 and 30 article. Okay, article 29 means protection of interests of minorities, and article 30 means right of minorities to establish and administer educational institutions. Okay, Article 30 means right of minorities to establish and administer educational institutions. So you know that in the last one of the classes I discussed about Ecolabial schools. Can you tell me then which article is now can be associated with the establishment of education Ecolabial schools? Ecolabial school খিনি প্ৰতিষ্ঠা কৰিবৰ কাৰণে কোনটো আৰ্টিকল জড়িত হ'ব পাৰে এটা এছ'চিয়েট কৰি জনাব পাৰিবানে? Then let's come to the next one, that is right to constitutional remedies. Right to remedies for the enforcement of the fundamental rights using 5 writs. Writs বুলি কওঁ, right? এনেকুৱা 5টা writs আছে যিকেইটা হৈছে like habeas corpus, mandamus, quo warranto, prohibition, certiorari, right? Now habeas corpus means to direct the release of a person detained unlawfully. Unlawfully detained কৰা person জনক এৰিব লাগিব, ৰিলিজ কৰিব লাগিব, সেইটো আন্ডাৰত কাৰ আন্ডাৰত আছে Article 32 habeas corpus writs আন্ডাৰত আছে. Then mandamus mean to direct a public authority to do its duty properly, right? To direct a public authority to do its duty is under mandamus. Then quo warranto means to direct a person to vacate an office assumed wrongfully. এটা জেগাত এটা পজিশনত যদি এজন মানুহে জবৰদস্তি বা তোমালোকৰ মানে আমি ক'ব পাৰো যে ভুলকৈ বা নিজাববীয়াকে বহি আছে যিটো তাৰ অধিকাৰ নাই, তেখেতৰ অধিকাৰ নাই, তেন তেওঁক ভেকেট কৰিবলৈ ক'ব পাৰিম সেই অফিসটো আন্ডাৰ quo warranto. Then prohibition means to prohibit a lower court from proceeding on a cause. এটা এখন lower court, higher court lower court মানে মানা কৰিব পাৰে prohibitionৰ আন্ডাৰত এটা কেছৰ ওপৰত further proceed কৰাটো. Then certiorari means the power of a higher court to remove a proceeding from a lower court. Okay. Then right to constitutional remedy under 30 কৈছে যে empowers the parliament to restrict or abrogate the fundamental rights of the members of the armed forces, parliamentary forces, police forces, intelligence agencies, and analogous forces. ঠিক আছে. So 33 is related to these different types of agencies to restrict or abrogate fundamental rights. Okay. Then Article 34 provides for the restriction on fundamental rights while martial law is in force, like military rule is in force. Then Article 35 means empowers the parliament to make laws on the fundamental rights. Now, এইখিনিত কিছুমান article কৈছো like Article 12 and 13 which are related to fundamental rights. Like Article 12 defines the state. State মানে আমি কাক বুঝো? State means the government and parliament of India, the government and legislatures of the states, all local authorities and other authorities in India or under the control of government of India. এই গোটেইখিনিকে আমি সংস্থা হওক বা যিকোনো গভৰ্ণমেণ্ট আৰু পাৰ্লিয়ামেণ্ট বা ষ্টেট লেজিসলেচাৰ হওক, লোকেল অথৰিটিজ হওক, যিকোনো অথৰিটি যিখিনি গভৰ্ণমেণ্ট অফ ইণ্ডিয়াৰ আন্ডাৰত আছে সেইখিনিক আমি ষ্টেট বুলি কওঁ আন্ডাৰ আৰ্টিকল 12. Then Article 30 means it defines laws in consistence or in derogation of fundamental rights. So Article 13 states that no laws can be made that take away fundamental rights. Etu bahut important. Now কিছুমান important judgment আছে যিখিনি আমাৰ fundamental rights ৰ লগত associate আছে, like in the Sajjan Singh case of 1965 the Supreme Court held that the parliament can amend any part of the constitution including fundamental rights. So Sajjan Singhত ক'লে যে আমাৰ fundamental rights কো amend কৰিব পাৰে, but 1967ত ইয়াৰ উল্টা হৈ গ'ল. The Supreme Court reversed its stance taken earlier in the verdict of Golaknath case. It said that the fundamental rights cannot be amended. Okay. Then in 1973, a landmark judgment ensued in the Kesavanand Bharti case. Kesavanand Bharti case to 1973, য'ত নেকি Supreme Court ক'লে যে although no part of the constitution, including fundamental rights, was beyond the parliament's amending power, the basic structure of the constitution could not be abrogated even by a constitutional amendment. Remember this. Okay, this is under Kesavananda Bharti case. কৈছে যিকোনো part, although no part of the constitution, fundamental rights হওক যিখিনি পাৰ্লিয়ামেণ্টৰ amending power বাহিৰত আছে, এইটো basic part of the basic structure of the constitution বুলি কম, আৰু এই basic structure could not be abrogated even by a constitutional amendment. This is under 1973 Kesavanand Bharti case. This is the basis in Indian law in which the judiciary can strike down any amendment passed by parliament that is in conflict with the basic structure of the constitution. Judiciary যিকোনো সেই amendment যিটোৱে আমাৰ basic structure to change কৰিব বিচাৰিছে গুটেটোকে strike কৰিব পাৰিব কাৰণত এইটো হৈছে আমাৰ কেশৱানন্দ ভাৰতী কেছৰ 1973 Supreme Courtৰ ভাৰতীয়ৰ দ্বাৰা right in 1981 the Supreme Court reiterated the basic structure of the doctrine. It also drew a line of demarcation as April 24th 1973, that is the date of the Kesavanand Bharati judgment, and that held that it should not be applied retrospectively to reopen the validity of any amendment to the constitution which took place prior to the date. Prior to that date, that is April 24, 1973. It is a demarcation hogol tar agor khini kotha etia nahe tar pasor khini kotha he ahibo ei Kesubananda Bharati judgmentor underot. Now let's discuss some important MCQs on fundamental rights. The first question is, which fundamental rights cannot be suspended even during emergency? Right to speech, right to religion, right to equality, right to life and personal liberty. Yes, the answer will be right to life and personal liberty. Then, which of the following articles of Indian Constitution contain the right to religious freedoms? Yes, I mean, that is coming under Article 25 to 28. So, Article 25 to 28, that's option A is the correct answer. They are containing right to religious freedom. Then, which of the following article of Indian Constitution guarantees equality before the law and equal protection of law within the territory of India? Who's Article 15, 14, 17, 18? The answer will be option B, that is Article 14. Then which of the following is correct with respect to right against exploitation? Option khini sai lo mo correct option to korisu. Right against exploitation or logot joito hoise prohibition of traffic in human beings and forced labors. Then which article of Indian Constitution abolishes untouchability? That's a famous article, and the answer is Article 17, that is option D. Okay, then today's last question, how many freedoms are guaranteed by Article 19? Article 19 mane ki asile? Right to freedom. Keta asile? Obviously, sota paisilu, so answer will be 6. So, my dear students, or what I can say that jin hokole amar ei videos khini khuni ase, so apnaloke hoyto ei lecture to ভাল পাইছে তেনেহলে of course comment কৰিব, like কৰিব আৰু চেনেলটো subscribe কৰিব। আগলৈ আমি এনেকুৱা বহুত important topic discuss কৰি যাম। So তেতিয়ালৈকে take care, bye bye, জয় অসম।